status from one non-immigrant status to another. We are also discussing extending non-immigrant status. Again, any status that is temporary, like visiting, like student, like a religious worker, like a temporary employment, like a business owner, any kind of status that is temporary. One can change from one non-immigrant status to another non-immigrant status. One can also extend the non-immigrant status from an expiration date to another expiration date. So that is what we are discussing today. So if you have come to the United States on a B1, B2 visa, visiting visa, and you want to extend your status before the expiration of your I-94, usually when people come in with visiting visa, they can give you any time between 1 week and 6 months. So if, for example, they give you 6 months and for any reason you want to extend that 6 months, that is what we are discussing today. Or let's say you come in with a visiting visa and you want to change your status. Maybe after coming to the United States, you realize that you needed to go to school and you wanted to change your status from visiting to student. Those are the kind of things we are discussing today. So if you have questions relating to non-immigrant status, extending or changing from one non-immigrant status to another non-immigrant status, send in your question as we proceed today. That is the topic we are discussing today. Ability to change status from one non-immigrant status to another. Ability to extend a non-immigrant status. So those are the things we are discussing today. So if you have any question relating to this topic, send in your questions so that we can discuss it. This is not a kind of topic that I can have extended conversation without specifically answering questions. So this is a topic that will require me to answer specific questions. So I expect you to start sending in your questions so that I will answer those questions as they come in. So we are discussing extending non-immigrant status or changing from one non-immigrant status to another. That is what we are discussing today. Maybe you have been a student, you've been in school, and now you are about to graduate. You are thinking of how can I change my status? Those are the things we are discussing today. Maybe you are here on visiting visa and your I-94 is about to expire. Maybe they gave you 6 months at the port of entry and you believe you still needed more time and you wanted to find out how you can extend your status. Maybe you have a temporary work permit that is valid for a specific time and maybe it is getting close to an end and you want to find out whether you can extend it or not and how to do that, or any other question relating to change or extension of non-immigrant visa. That is what we are discussing today. Start sending in your questions. Yes, I see that I have some questions here. So I'm going to start right away. The first question. I recently got married to a US citizen, but I heard that consular processing can take a long time. Can I come in on a visiting status and then immediately have my spouse file for me for green card? Well, the answer to that is a little complicated. The simple answer is yes, but there are some issues that you have to take into consideration. The writer of this question, I don't know if you have an existing visa or if you are going to apply for a visiting visa. Because if you have an existing visa, yes, you can come in. Once you come in, you can get married to your spouse and then your spouse can submit a petition for you. Oh, sorry, the question says you recently got married, so you're already married. Yes, you can come in and your spouse can petition for you. However, the reason I said that I don't know if this person already has a visa or not, if you don't have a current visa, if you are going to apply for a visa, then intent becomes an issue. If you are coming to the US so that your spouse can file a petition for you, but you apply for a visa and you tell them that you are coming to visit, that may be seen as misrepresentation. That may be considered as misrepresentation. But if you have an existing visa, yes, you can come in and your spouse can file a petition for you. Even if you don't have an existing visa, if you are just going to apply, the most important thing is to disclose the intent. For example, you can tell them, I want to visit my spouse. The moment you indicate at the time of application for visa that you have a spouse who is a US citizen, then there is no hidden agenda anymore. So if you come in, your spouse can file a petition for you. But if you have an existing visa, that even makes it easier for you to come in so that your spouse can petition for you. Actually, if you come into the US, it is much faster for your spouse to file the petition and get approved than when you are outside the US. This is because when you are in the US and you apply, your spouse will file a petition, and on the basis of that petition, you can apply for permanent residence. You can apply for employment authorization. You can apply for travel document. So all these processes can be done simultaneously, and they are done with only one agency, which is United States Citizenship and Immigration Services. On the other hand, if you are applying from outside, it will be a four-stage process, which takes much longer. The United States Citizenship and Immigration Services will have to conduct the first stage. That is, they will have to adjudicate the petition filed on your behalf by your United States citizen spouse. Upon the approval of that petition, it goes to the next stage, which is National Visa Center. That is under the Department of State. It is there you will submit an immigrant visa application, immigrant visa fee, and you submit police report, and you from every country that you have lived since age 16. So when they complete the process, then it goes to the third stage, which is the US Embassy in your home country. That is where you will now need to conduct medical examination, and you also have to attend an interview. Now, assuming everything goes well and they issue you a visa, that is still not the end of it. You come back to if you are able to change your status, you can still do it even while the initial I-94 has expired, but an extension application was submitted before the expiration of the initial I-94. You can actually change your status and you can remain here legally too. The next question, expired. No, that is a no-no. And that is one of the reasons we are doing this program. The thing is, America is a country of law. You cannot violate the law and expect the government to reward you for it. In this country, nobody is above the law. And if anybody has a doubt whether some people are above the law, you can see what is happening right now to the former president. You can see that despite being the former president, the system does not allow him to operate above the law. Nobody in this country is above the law. So the issue is, if you come into this country and they gave you 6 months at the port of entry, and you stay here, you spend the 6 months and you remain here, then maybe after 10 months or something, or even after 7 months, you suddenly realize you needed to apply for an extension or you needed to change your status. No, that application is going to be denied. There is no exception. The application will be denied because the moment you have violated your status, at the expiration of that 6 months, on the 61st month or 6 months and 1 day, you become illegal alien in this country. And after that, you cannot apply for a change of status. And if you do, it's just going to be a waste of money and waste of time because that application will be denied. The next question, Oh, I have to re-answer that question. I want to give a follow-up to that question because the question says, can I file for an extension of status if my current visa has already expired? I think I answered that question on one part. I want to answer it in a different way now. There's a difference between I-94 and visa. The way I answered the question, I only addressed I-94. So if you are outside the US, so if this question is talking about somebody whose visa has expired, material when it comes to what you can do and what you cannot do inside the United States. But if your visa is expired while you are outside the United States, then that will be a no-no. You cannot do that. So I believe that clarification is very important. The next question. I came into the country on an R1 status. Can I work somewhere else while also working for the church? No, you cannot. R1 is even particularly stricter than any other non-immigrant status. In my opinion, when it comes to non-immigrant status, in order of strictness, the most strict one is R1, religious workers. After that is F1, student status. If you are on R1, you are authorized to work solely for the employer, for the petitioning employer, the religious organization that filed the petition on your behalf. That is the only organization you can work for. You cannot work for any other organization. If you do, that is a violation of your status. The next question. I would like to apply for a seasonal job that starts in March of 2024. Which non-immigrant visa will I apply for? And when should I start the application? Well, I don't understand what kind of seasonal job this person is talking about. To the best of my knowledge, the only seasonal type of application is a agricultural worker, H2, H2B petition, agricultural worker, and it is only valid for 10 months. Because it is seasonal, it is valid only for 10 months. It's agricultural worker. So it's similar to H1B, except that for H2B, it is available for unskilled labor, unskilled workers, because it's agricultural workers. So they have limited number too, the same way we have for H1B. So if that is the one you are talking about, the first thing is to find an employer, an agricultural employer that will sponsor you. And of course, the petition, it is usual, immigration usually announces the start date. And of course, they will also announce it as soon as they have the number, as soon as they have exhausted the available number. So they are the one that announces that. But primarily, you need a sponsor, because even though it is temporary, some agricultural work petition actually requires labor certification. So it's not that it's automatic. No, it's not. But the starting point is to find an employer who will file the H2B visa on your behalf. The next question. I'm about to graduate from school, so F1 is about to expire. Does the OPT count as a status, or do I need to file something else? Yes, your OPT count as a status. Usually, that is why it is important that you apply for OPT before graduation. If you wait until after graduation and then apply, then that means there is a gap in your status. So the OPT application may be denied. So it is always required that you apply for OPT before the end of your program. So once your OPT is approved, the work authorization for 1 or 2 or 3 years, depending on whether you study STEM subject or not, that is an extension of your F1 status. And of course, if you plan to go back to school or change your status, you have to do it before the expiration of your OPT. So whatever work authorization they gave you, it is an extension of your status. But if you travel out expired, you can continue to use it while on OPT. But OPT is an extension of your F1 status. The next question. Are there non-immigrant visas for all professions, or are they limited to certain professions? Yeah, there are non-immigrant visa for every profession. There's no H1B is for every single profession. There's no exception. For as long as you meet the requirement, H1B is considered specialty occupation. Specialty by immigration interpretation, it means that for you to be eligible for H1B, you must have studied a program that requires a minimum of 4-year degree in college or university. So you have to have studied a program that requires a minimum of 4-year degree. In other words, any course that is associate degree does not qualify for H1B. So in order to qualify for H1B, you have to have had a minimum of 4-year program, a degree that requires minimum of 4-year study. So that is the meaning of specialty occupation. But once you meet the requirement, it doesn't matter what your field is. For as long as your employer, your sponsor is within your field, because you have to get employment, you have to get a sponsor in the same field that you study. For example, you cannot go to law school and be a lawyer and then get a medical a clinic or an hospital to file H1B for you. That petition is going to be approved. Or you cannot be a law office and then attempt to sponsor somebody who is a medical doctor. That application is going to be approved. So it has to be whatever the beneficiary studied must be relevant to the business that the employer is doing. So those are some of the requirements for H1B. But any profession at all can use H1B. In fact, for those who studied medicine outside the United States, usually H1B is what they use to do their residency in the US. For once they pass all the necessary exams and they needed to do residency, it is H1B that they use to do that residency. So it doesn't matter what your profession is, whether you are an engineer, you are an accountant, you are a lawyer, whatever, even irrespective of your profession, every single profession can get H1B for as long as you meet the requirement of H1B and your employer is also doing business that is related to what you study. The next question. My sister is signed off her parental rights to me. I am now their legal guardian. Will I obtain a visitor's visa for my niece and nephew so we can all visit the US? I'm not sure I understand this question. My sister is signed off her parent. My sister has signed off her parental right to me. I'm now their legal. It does not give you any legal right. So it only means that your sister gave up their rights. So that's it. There is nothing legal that is giving you parental right over those children, except you follow through the process of adoption. Is the processing time for non-immigrant status application shorter than immigrant status application? The processing times are different. They are not the same type of application. So it is not comparable. It's like trying to compare apple and oranges. They do different things. So it's not something that one can compare, because non-immigrant status, there are some non-immigrant status that that the processing time is over a year, whereas there are some immigrant applications that are approved in less than a year. So you can't really compare the two. They are two different, distinct things. So, I mean, apple is apple, orange is orange, pineapple is pineapple. So you can't compare them. They do different things. So the processing times are completely different. So it's not something one can compare. The next question. I'm a pilot outside of the US. What type of non-immigrant status will I apply for that will allow me to work on flights that go into the US? Well, this question is not detailed enough because the fact that you are a pilot does not mean you'll be allowed to fly a plane in the US. Are you certified to fly in the US? Do you have all the US certification, or are you still coming here to apply for those certifications? So if you are coming here to apply for those certifications, then you can apply for M visa. But if you are already a pilot and you just want to fly, you need to have those certifications before you can even think of flying a plane in the US. So the fact that you are a pilot in your country does not authorize you to fly a plane in the US. But if you are coming in to get the training or the certification required to be able to fly, then you need an M visa. The next question. I was a victim of criminal activity in my home country. Is there a type of non-immigrant status that I can apply for? What would be the process that it for that type of application? No, 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 no. I mean, what has you being a victim in your home country, what has that got to do with America? That's not, there's nothing like that. I mean, America is not responsible for your upkeep. Remember, there is something in international law called sovereignty. Every country is sovereign, and every country has a government, and every government has a responsibility to protect its own citizens. So, if you are a victim of criminal activity in your home country, it is the responsibility of your home government to protect you. So that does not give you any form of immigration benefit or status in the US. There's nothing like that. It is only if you are a victim of criminal activities in the United States. If you are already here and you are a victim of criminal activities, it is only then that you can get immigration benefit, because at that stage, American government has a responsibility to protect you. So if you become a victim while physically present in the United States, that is the only time that you can get some form of immigration benefit. But being a victim of criminal activities in your home country does not give you any benefit here in the United States. The next question. I would like to apply for a student exchange program. What will I need to do to apply? Well, you can't apply for student exchange program. Those are sponsored kind of visa. That is J visa. So you need to look for a sponsor. You need an organization that will sponsor you for a J visa. So that's not something you can do. You need a sponsor. You need an organization that will sponsor you for a J visa. The next question. I live in Mexico, but the trucking company I work for is housed in the US. Will I need to apply for some type of non-immigrant visa status to be able to work and travel back and forth for this company? Oh, yes. Mexico is part of NAFTA. NAFTA is North America Free Trade Agreement. So Mexico is part of NAFTA. So all you need to do is for your employer whose office is located in the US to apply for you. It is called TN visa. So it's your employer who is located in the US that will apply for you. But Mexico is part of North America Free Trade Zone. The next question: I came in with a B1 B2 visa, which is likely to lapse in 2 months. In 2 months' time, how do I go about extension of stay? Well, if you are talking about B1 B2 visa, this question does not address the I-94. So if your B1 B2 visa is expiring in 2 months, are you referring to the I-94 or are you referring to the visa? I've stated it several times. There's a difference between a visa and I-94. You can have a visa that is valid for 5 years, 2 years, 10 years, and still be illegal in the US. And you can have a visa that is already expired and you can still be legal in the US. So a visa is a document that is only useful for people when they are outside the US, physically outside of the United States. I-94 is the document that is given to you when you enter the United States, telling you how long you are authorized to stay in the US. So if this question is referring to the I-94 that is about to expire in 2 months, then all you need to do is to apply for an extension of the I-94 by filing Form I-539, Form I-539, application to extend a non-immigrant visa, a non-immigrant status. Of course, you must have a valid reason. You can't just say, oh, I just want to extend. I mean, 6 months, especially if they gave you 6 months. 6 months is a lot of time. If you told them you are coming in here for a temporary visit and you've been here for 6 months, so if you are requesting an extension, you need to have a valid reason. You can't just say, oh, please extend it. No, they may not extend it. You have to provide a valid reason why you need an extension. But you apply for an extension. That is the process, and by completing Form I-539. The next question. My child is studying in the United States under F1. He has never been on his own. Is there a way I could get a visa to go live with him while he completes his studies? No, they will not give you visa for that. I mean, if you want to live in the US, you have to have a reason. You have to have a legitimate route to apply for that. That you have a child in the country going to school is not a legitimate reason for you to live here. So there's no visa category for that. The next question. I was working on an H1B and now have been admitted to a university as an F1. Do I need to return to my country to apply for a student visa? No, you don't need to. If you are already on H1B, all you need to do is just to submit application for change of status from H1B to F1. That is all you need to. You don't need to go back to your home country to do that. Just get the I-20 from the school that gave you admission and then apply for change of status from H1B to F1 status. Next question. Can I go on vacation to Mexico for spring break and return back to continue my studies on my F1 visa? Yes, if you have F1 visa. Again, I've said it over and over and I keep hammering on it because whatever information you get on this program is 100% accurate. I would never give you information if I'm not 100% sure of my answer. So I keep pointing it out. There is a difference between a visa and I-94. So whoever sent this question, if you have a valid visa, yes, you can go on vacation into Mexico or even to any other country and come back on your F1 status. However, if you enter the United States on a different status, let's say you came in with a visiting visa, and then you apply for a change of status while in the US to student status, that means that if you step out of the US, you will not be able to come back unless you get a visa in your new status. Let me explain this again. Let's say somebody entered the United States with F1 visa. Usually, F1 is valid for duration of studies, and you are still in school. Then comes spring break. Your visa is still valid. You want to know whether you can go to Mexico or to any other place for spring break. The answer is yes. On the other hand, let's say you came into the US with a B1, B2 visiting visa. While in the US, you apply for a change of status to student, to F1. Your application was approved. Upon the approval, immigration will give you a new I-94 that will show that your status is valid for duration of studies. Immigration does not issue visa. That I-94 does not equivalent to visa. So, if that is your situation, before you go to Mexico, be prepared to go to the US Embassy in Mexico to apply for F1 visa. And I need to tell you, like any other non-immigrant visa, every non-immigrant visa is 100% discretionary. So you can get to Mexico, go to the US Embassy, apply for F1 visa, the embassy may deny you. So it is not the same with somebody who entered the US on a student visa, whose visa is still current, has not expired. Migrant visa, if you meet the requirement. Yes, that is possible. The next question. My change of status was denied. If my I-94 has already expired, can I still apply for a different change of status? No. No. If your I-94 has already expired, then you cannot apply for any change of status, because as I stated at the beginning, in order to be eligible for a change of status, you must be maintaining legal status. The moment your legal status is expired, you cannot change your status. So if your change of status request was denied, and at the time it was denied, your I-94 has already expired, you are no longer able to apply for a different non-immigrant status. But on the other hand, if your application for change of status was denied and your I-94 has expired, you still have the opportunity within 30 days to file a motion to reopen, to attempt to overcome the reason for denial. Because whenever the change of status is denied, immigration will give you a valid reason why your application is denied. Even though your I-94 may have expired at that point, if you have a valid reason or documentation or additional evidence to overcome the ground for denial, you can still apply for a motion to reopen and present the additional evidence so that your change of status can still be approved. But you have 30 days to do this from the date the change of status application was denied. The next question. I was here on F1 and my I-94 says DS, duration of status, but I didn't have money to pay for a semester, so I was not actually in school. Is it possible for me to go back now? Do I apply for a new F1? Well, once you are out of school for one semester, immigration will have been aware, because that is one of the purposes of service, S-E-V-I-S, service. So once you don't register, immigration, ICE, when I say immigration this time, I was referring to ICE, Immigration and Customs Enforcement. They are the one that regulates student status. So ICE will have had knowledge of you not being in school. So if you have now decided to go back to school, you will need to apply for what is called reinstatement. You will need to apply for a reinstatement. And in order to apply for reinstatement, you will need a new I-20 from your school. You will need to provide an explanation as to why you are out of status in the first place. And of course, you must not have been found to work illegally. So if you have engaged in unauthorized employment, you will no longer be eligible for reinstatement. But if you have not worked illegally. The next question. I am here on H1B, but I just lost my job. Can I quickly find a new employer? Do I file a new extension of status? Well, if you are already on H1B and you have lost your job, you have what we call 180-day portability rule. It's like a grace period. Within that 180 days, if you find a new employer, you can file a transfer of your H1B. You can apply for a transfer of your H1B to the new employer, but you have 180 days. Excuse me, that is your maximum grace period. So within 180 days, if you are able to find a new employer, you can get you can transfer your H1B to the new employer. That seems to be the last question I have so far. Do you have more questions there? Oh, okay. Okay, next question. I had someone fill out my visa information for me. I'm assuming this is visa application. Okay, I have someone filling my visa application for me, but the information was incorrect. I have now gotten married to a US citizen. Will the false information get me in trouble? Do I need to disclose this? Yes, the false information will definitely get you into trouble. And it is better to disclose it now and apply for waiver. I mean, I will advise you to consult with an experienced immigration attorney who can help you fix this. But it is better for you to disclose it than for immigration to find out. Because if you disclose it now, definitely it will affect your application. It will cost you more money because now you will have to apply for a waiver. Your wife, your US citizen spouse, will be your qualifying relative for the purpose of the application for waiver. But it is better to go through that pain now than wait for immigration to find out later. The reason is this: if immigration found out at any time, even after you have become a US citizen, your citizenship will still be revoked. The law is that you cannot build something on nothing. You cannot build something on nothing. So if you obtain your citizenship by fraud, by not disclosing a valid information, at any time, if they find out, you will not only lose your citizenship, you may also go to jail. In actual fact, I have one example. I know of someone who became a US citizen in this country as far back as 2006, started using American passport as far back as 2007. Then in 2016, the government found out that he actually had a different name. He had used a different name which he didn't disclose. Of course, they found out more than 10 years after he became a citizen. Of course, the painful part is that because immigration cannot arrest a US citizen, immigration cannot revoke citizenship, they have to involve the FBI. So, FBI will arrest the person, prosecute the person. Of course, a federal court will have to give an order revoking that citizenship. But I've seen it happen based on non-disclosure of information. I've also seen it happen based on fake date of birth. I've seen it happen on different levels. So it is better to face the challenge right now. Disclose it on your own, disclose it voluntarily. Of course, it will affect your application, but you will be able to apply for a waiver. And once the waiver is granted, that issue is resolved permanently. So it's better to fix it now than allow it to wait for you in the future where the consequence may be fatal. The next question. I am on R2 as the spouse of a religious worker. Can I work or go to school on this status? If you are on R2, you are in valid legal status. You can go to school. You can get driver's license. You can do everything that someone who is legal can do, but you cannot work. R2 does not authorize the beneficiary to work. If you work, that will not only be a violation of your status, but it may also affect your principal. So you are not authorized to work on R2, but you are allowed to go to school on R2. Keep the questions coming. That's the last one I have for now. Okay. Okay. Another one just came in. I was just granted R1 visa, but I have now applied for adjustment of status. Do I need to apply for an extension of my U visa? Okay, do I need to apply for an extension of my R visa before the I-94 expires? If you have applied for adjustment of status, you no longer need to apply for an extension of your R status. Adjustment of status is actually it invalidates your R status. So you are no longer, the moment you submit your application for adjustment of status, you are no longer in a non-immigrant status. Remember, adjustment of R1 is one of the non-immigrant status, temporary status. Adjustment of status, on the other hand, is a permanent status. You are applying for green card. You are applying for permanent residency when you apply for adjustment of status. So the moment you have submitted your application for adjustment of status and immigration has issued a receipt notice, you are no longer on R1 from that moment. So there is no need to extend something that is no longer useful. So from that moment, your R1 is no longer useful. So there is no need to extend it. It is your adjustment application that keeps you in status. So that is why when you submit your adjustment application, you are supposed to submit application for employment authorization along with it so that you can continue to legally work for your employer. This is very important, very important. I remember some years back, probably about 15 years ago now, there was someone who was on R1. Now, of course, I didn't do that case. They only came to me after they got into trouble because they didn't know all this little information that we are giving out today. That person was on R1. Now, when the I-360 was approved, the person submitted application for adjustment of status. Now, not realizing that from that moment the R1 was no longer valid, the person did not apply for employment authorization, but he continued to work for the employer. The application for adjustment of status was pending for about 2 years. After some time, immigration issued a request for evidence, asking the person to show evidence that he has been working legally for the employer. Of course, there was no evidence of, there was no work authorization. So even though he was working for the same employer, but he was working illegally because he did not realize, one, that the R1 was no longer valid, and he did not realize, two, that he needed to apply for employment authorization. So that is why we are giving out this information. Little things create problem for people out of ignorance. Unfortunately, ignorance of the law is no excuse. So when you apply for adjustment of status, it invalidates your R1 status. When you apply for adjustment of status, you are supposed to apply for employment authorization along with it. So it is only after you do those two that you can legally continue to work for the employer. The next question. Okay, this is a two-part question. So part one. Hello, sir. A couple, husband and wife, entered the US on B2 visa. Then the husband applied for F1 alone, and the wife was still on B2. After the change of status was approved, wife was returned on B2. She was denied. Oh, so wife went back to her home country. Okay. She was denied at the port of entry and her B2 cancelled, but was granted permission to withdraw the application to enter the US. What can be done? Well, honestly, when I see questions like this, I see value in what we are doing. I see value in giving out information. I've said it 1 million times. Every single non-immigrant visa is discretionary, 100%. I'm sure that the CBP, those are the people that admit people into the US. The CBP must have seen some form of red flag. The fact that your husband changed to F1 does not guarantee you admission into the US, because F1, like every other non-immigrant status, is 100% discretionary. It's a discretionary thing. There is no room for appeal. There is no room for waiver. There is nothing you can do. Absolutely nothing. It is 100% discretionary. The only other thing, maybe you reapply for B1, B2 visa, which again is discretionary. So there is really nothing that anyone can do to fix this problem. It is entirely discretionary, 100% discretionary. Maybe if there is additional information, you may be able to apply for a non-immigrant visa waiver if you want to apply for a new visa and you have a reason to come to the United States, and that reason must be something that, I mean, you have to be able to justify it. It cannot be, I want to come and visit. It cannot be, I want to come for vacation. No. It cannot be, I want to attend a wedding. It cannot be, I want to attend a graduation. It cannot be any of those things. It has to be something that goes beyond all that. Even at that, again, the waiver too, like the non-immigrant visa, is discretionary. So legally, there is really nothing I can tell you that if you do this, you'll be given a visa or you'll be allowed to come back into the country. No, there's nothing like that. 100% discretionary. Okay, follow-up question. Can she apply for F2 now? Yes, yes. But again, entry into the US. I don't know if there have been prior entry into the US. I don't know the kind of questions they ask at the port of entry. I don't know what they told them at the time they were applying for visa and what they told them at the time of attempting to enter. Because unlike in the past, the systems are now interwoven. When CBP officers are looking into the computer, they are able to see what information you provided when you apply for visa. So if, for example, you told them when you apply for visa that you are going to Maryland to attend a wedding, and then when you purchase your ticket, you bought a ticket that brought you to Atlanta, and then you got to Atlanta, your husband applied for, maybe you got this visa as a family, then you got to Atlanta, your husband applied for admission and changed his status to student. So when the officers see this type of information, there is an element of misinformation. There's an element of misrepresentation. So that may be the reason. I'm just speculating. It may not be. That is why people like this, I think it is better to do a one-on-one consultation with an experienced immigration attorney who may be able to look further into it. But the general rule is that there is no waiver. There is nothing you can do legally. Non-immigrant visas are discretionary. The reason I'm explaining this is that the fact that your husband is on F1 does not even mean that you will be given F2 visa. If any of those things that I listed was the reason why you are denied admission, that will still go ahead to prevent you from getting F2 visa. But you may not know unless you try. So if you want to try, you can get your husband to apply for F2 I-20 for you. Your husband must show his transcript to confirm that he's actually in school. And then you give it a trial. But again, I don't know the details of what transpired at the port of entry. Usually, before a CBP officer will prevent somebody from entering, there must have been a kind of a sort of red flag. Because CBP is different from visa. It's different from the embassy. You can be denied visa for any reason. You can be denied visa for no reason at all. But usually, based on my experience, CBP will not deny somebody entry for no reason. You can be denied visa for no reason, but you may not be denied entry for no reason. So there must have been something that the CBP officer found, which of course I'm not going to be able to know. But again, if you consult with an experienced immigration attorney, part of what you can do is to apply for FOIA. FOIA is requesting a copy of the record, copy of what transpired between you and the CBP officer. You can apply for FOIA. Everything will be in the record. They will state in your record what the problem was, why you are denied admission. Because this is a country of law. Even though the officers have discretionary authority, they don't exercise their discretion arbitrarily. They still have to have a reason to exercise it. So it may be a wise step to apply for FOIA before you take any other steps, including applying for F2 visa. So you may want to apply for FOIA first so that you know what the issue is. If after that you decide to apply for F2, you know what the issue is and you'll be able to address it. Do I still have more questions? Okay. Waiting for how many more questions? One? Okay. Waiting for the last question. You can just read it. Okay. Thank you. Hello, sir. Thank you for all you do. I'm currently on a STEM OPT program and my EAD will expire next year, August 2024. Should I apply for NIW or wait for my spouse to finish her nursing program? If I go through nursing EB3, at what point can we get green card? Well, my simple answer to this is if you are eligible for EB2, go ahead and do it. If your spouse is eligible for nursing EB3, let your spouse also process it. The reason is this. Both of these visa categories, NIW is actually EB2 category. Nursing is EB3 category. Both of them, they are affected by visa bulletin. So if you have the opportunity to apply for both, do both. Whichever becomes available first is what you will do. Because even right now, as we speak, for NIW, they have they have retrogressed, I think, to 2018 or 19. 2019. They have retrogressed right now. So even if you file the NIW and the petition is approved, you still cannot apply for green card right now because the visa bulletin has retrogressed back to 2019. So, and I know it is not the same thing with the EB3, even though both of them have limitation, but their availability differs. So if you are eligible for both, go for both. So whichever comes first, you apply for green card based on which of the two comes first. So that would be my advice. So I think we have come to the end of the program for today. It was nice answering all these questions. Remember to join us next week, every Wednesday, 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. Join us every Wednesday. Remember to subscribe to our channel so that when we go live, you'll be notified. And remember too, to tell your friends, tell your family members, tell your colleagues. You will agree with me that what we are doing is useful. Even if it is only one person that benefits, you will agree that it is worth the while, because ignorance of the law is not an excuse. There are simple mistakes that people make that create major problems. That is why we are doing this. We are not doing this for any financial gain. It is free of charge. And no question is outside the limit. You can ask any question. Join us again next week. The only way to show appreciation for what we are doing is by telling other people so that other people too